If the 22 July MC Singla hearing yesterday at the Supreme Court were a boxing match, the scorecards would show retirees edging ahead. The division bench didn't deliver a knockout, but the momentum was unmistakably with bank retirees. A hard-won round in a long fight for pension justice.
After IBA's unimpressive performance, the bench, the sitting judges, Justices Vikram Nath and Sandeep Mehta, were scathing in their responses during oral arguments. They tore shreds off IBA, the banks and their advocates, as they tried to circumvent the provisions of Regulation 35.
Justice Vikram Nath took no prisoners. He drove a coach and horses through the IBA's arguments. And by 3:30 p.m., the banks were clinging to the ropes. It was a bruising session, and the bench made clear who was absorbing the heavier blows. But let's not get ahead of ourselves just yet.
So let's get back to the fundamentals of the MC Singla case. Now, when you sign a contract, you generally expect certainty. But what happens when the massive institution, who is the other party to the contract, decides to just wait you out until you're out of biological time?
Exactly. So today, in this deep dive, we're looking at a pretty staggering situation. Over 7.8 lakh elderly bank retirees finally saw a crack in this 18-year war of attrition at the Supreme Court yesterday.
Yes, yesterday was July 22nd, 2026. And the landmark MC Singla case just hit a massive turning point.
It really did. So let's walk through how the hearing actually unfolded.
Well, you could actually feel the whiplash in court number 2 yesterday. I mean, before they even broke for lunch, the petitioner's lawyers were trying to rely on this old timeline from 1986.
Oh, wow, 1986. That is going way back.
Yeah. But Justices Vikram Nath and Sandeep Mehta, they were having none of it. They immediately demanded to know about the regulatory amendments that came after that.
Right? They wanted to see the current statutory groundwork, not just the historical context, which makes sense. You can't really argue a 2026 case using only 1986 logic.
Right? And that really set the stage for the afternoon because post lunch, the entire debate pivoted strictly to the math.
And the math is where it gets crazy, right?
Oh, absolutely. Legal teams started presenting new calculations based on hints from the bench. They were leaning heavily toward a prospective implementation.
Wait, prospective, meaning adjusting the pensions starting right now rather than making retroactive adjustments all the way back to 1995.
You got it? And the financial stakes of that prospective versus retroactive shift, I mean, they are astronomical. It's exactly why IBA threw up massive roadblocks.
So it's like a company finally agreeing to upgrade your subscription today, but flat out refusing to refund you for the 30 years they under-delivered on the old plan.
That is a perfect way to put it. The compound interest on that missing service is the real prize here. And the battleground for all of this is something called dearness allowance, or DA.
Right, the allowance that's meant to combat inflation.
Yes, but DA acts as a multiplier. If the retirees can prove the DA was successfully merged into their basic pension back in the 90s, well, the compound math over 30 years just totally explodes the payout.
So naturally, the banks fought back hard.
Oh, for sure. Dhruv Mehta, the counsel for IBA, leaned on a highly technical defense. He pointed to the 1995 Bank Employees Pension Regulations, the BEPR.
Okay, and what was his argument there?
He argued that they contained absolutely no updation clause.
Wait, what does that mean in plain English?
He claimed the 1995 rules never explicitly stated that older pensions would be automatically updated to match modern wage scales. He also argued that the Reserve Bank of India's own updation scheme legally does not apply to these public sector banks.
Hold on a second. You're telling me these banks manage over 200 lakh crore rupees in assets, right?
Yes, massive amounts of money.
And this pension was funded by the employees' own money, starting way back in 1993. So they're using a technicality about a missing clause from 1995 to dodge paying out. A payout estimated at around 95,000 crore.
It sounds like pure institutional stonewalling, doesn't it?
IBA-DFS have had plenty of practice over the last 20 years, because that's exactly what it sounds like.
Well, the Supreme Court seems to share your skepticism. They weren't convinced by this technical dodging at all.
Oh, really? So what did they actually do?
They ordered the Indian Banks Association, the IBA, to undergo a forensic audit. By the next adjourned hearing on August 12th, 2026, the IBA must submit detailed affidavits and original settlement records.
Wow, so they have to definitively prove exactly how that dearness allowance was merged into basic pensions across the various settlements.
Exactly. And Justice Vikram Nath issued a very sharp warning. He said merely handing over the documents won't automatically be accepted as the absolute truth. He was putting the banks on notice in no uncertain term.
So the judges are essentially saying, show us the receipts. Don't just quote a 1995 rule book. Show us the actual math you used when you made these bilateral settlements.
Yes, the court is going to dig into them to check for constitutional parity. They are evaluating these pensions not as a gift but as a deferred wage.
A deferred wage, that's a crucial distinction.
It is. Under the law, if a pension is a deferred wage, retirees holding equivalent ranks must get equal payouts,
That's interesting.
regardless of whether they retired in 1996 or 2016.
So by treating it as a deferred wage, it legally traps the banks from treating older retirees like second-class citizens.
Right? And when you zoom out and look at all these sources, you're really seeing a coordinated 2-decade delay by the Department of Financial Services or DFS and the IBA.
Yes, they dragged this across 5 separate bipartite settlements. They essentially turned a basic contractual promise into a literal war of attrition against the elderly, the very people who built today's India's modern financial infrastructure.
It really is a profound test of whether institutional promises hold any real weight when billions of rupees are on the line.
So the August 12th forensic audit is going to be the absolute moment of truth for those DA merger documents.
It's going to be epic. The banks and DFS are well advised to bring their A game on the 12th of August. It remains to be seen if in time posterity will come to know the date as the glorious 12th.
And that brings us back to the contract we began with. If a Gazette notified bilaterally settled 1993 agreement can be stalled for 18 years through bureaucratic loopholes, what does that say about the integrity of the Indian state can honor a contractual obligation?
Thank you for watching. Please subscribe and leave a comment for the algorithm. It ensures our podcast reaches people like you who needs to see this. Namaste.